So welcome to this forum for the Modern Criminal Law Review Plus, forum on criminal law literature and history. I'm Simon Stern. I teach at the University of Toronto. I'd like to thank Marcus for inviting me to do it and our four speakers for participating today. So criminal law is one of the paradigmatic, if not the paradigmatic, field in law and literature for reasons of both form and content. And I think the range of papers that we're going to have today will illustrate that. So the format will be that I'll introduce a speaker, they'll speak for 10 minutes about their paper, we'll have 10 minutes of Q&A, and then we'll go on to the next. And we will just get started with the very first one, Hannah Walser. Hannah is a PhD graduate of Stanford in English and American Literature. She has her JD from NYU, where she served as a Furman academic scholar. She's been a junior fellow at the Harvard Society of Fellows. She's author of Writing the Mind, Social Cognition in 19th Century American Fiction, recently published by Stanford. And among her publications in law journals is Vagueness, Double Consciousness in the Criminal Law, a Cognitive History, which came out in Critical Analysis of Law last year. Hannah's paper today is called Free Indirect Hearsay. Hannah, please take it away.
Great. Thank you so much, Simon, for putting this issue together. Thanks to Marcus for putting the event together. And obviously, thanks to all the workshop participants. I'm really excited to talk about your work today. So I thought for the 10 minutes that I have, I'd just give some quick background on the text I'm working with and on the concept of free indirect discourse, which if you don't have a literary background might be unfamiliar. Even if you do, a refresher might be nice. And then I'll kind of summarize the three big kind of chunks of my argument as I see them, and hopefully, if I have time, talk about some kind of ways I'd like to expand on things or revise. So the text I'm working with, it's just one, but it's very rich and complex and problematic. It is Daniel Horsmanden's Journal of the New York Conspiracy of 1741. There's a much longer title that I won't read. But Horsmanden was a justice of the Supreme Court of the province of New York in 1741, which was a year when a rash of mysterious fires broke out that panicked the residents of New York City, and also led the white residents of the town to the conclusion that this was the product of a rebellion among the enslaved Black people of the city, possibly in conjunction with various Spaniards, Catholics, other shady elements. So their belief was that there had been a plot to burn down the town and raise a new government on its ashes. So a grand jury was convened to investigate. Horsmanden was one of the jurists presiding over the whole proceedings, including the trials. And over the course of the next few months, hundreds of people were arrested. About 30 Black men were executed, along with 4 white people, and more than 70 were transported into enslavement in the Caribbean. So Jill Lepore has compared this to like a more kind of a bigger and more violent version of the Salem witch trials. And as that comparison suggests, there's some variety among scholars in terms of whether people think there was in fact an underlying conspiracy of any kind. If there was, what were its goals, who was involved. I am trying to kind of put all those questions to the side, even though they're very, very interesting, because from my point of view, what interests me is how the participants in the proceedings, so that would be the accused conspirators, witnesses, informants, and the jurists themselves, including Horsmanden, used language, and in particular used secondhand speech to make an organized plot out of a cluster of kind of dubiously related events. And I think that one of the tools they used is free indirect discourse, which I'll call FID just to save precious seconds. So FID, even if you're not familiar with the term, you would probably recognize it. It typically consists of, it's fictional, usually a fictional formal device that consists of a narrator reporting on a character's speech or thoughts, but instead of directly quoting, the narrator retains the character's diction and often grammar, while shifting the verb tense and pronouns to the point of view of narration. So an example makes it easier to see, I think, one from the most canonical practitioner, Jane Austen. This is from Persuasion, and Eliot is thinking here, "This was dreadful. Would they only have gone away and left her in the quiet possession of that room, it would have been her cure. But to have them all standing or waiting around her was distracting." So if we were hearing directly from Anne, she would have said something like, "This is dreadful. If they would only go away and leave me in the quiet possession of this room," etc. But in FID, we retain not just the kind of phrasing dreadful, but also the sort of exclamatory structure, but we shift the tense and pronouns. So here are some passages from Horsmanden. So then the deponent told her, this is a summary of a deposition, "Sure, you had better tell everything that you know, for that may be of some service to your father." Upon which she said no, for that they were doing all that they could to take his life away, and that she would sooner suffer death and be hanged with her daddy, if he was to be hanged, than she would give them that satisfaction of telling or discovering anything to them. Or another, Cuff said they could not do it. "Yes," says Rom, "will do well enough." And he encouraged them and said he would stand by them, and that the sun would shine very bright by and by, and never fear, my lads. So these are inconsistent and imperfect examples of FID. They don't have that Austenian smoothness. They kind of stagger in and out of direct or indirect discourse, especially you can see it in that sentence I just read. And he encouraged them, indirect, said he would stand by them and that the sun would shine very bright by and by. There's something that I think I would argue is FID, and never fear, my lads. That's a slip into it, something like a direct quote. But nonetheless, I think each of these passages has a recognizable sort of proto-FID. And the first kind of chunk of my argument is just trying to establish that that is true, because this is actually, from the point of view of literary history, noteworthy. So 1744 is when the journal was published, and it's not a work of fiction, of course, at least not overtly. The conventional wisdom is that FID started to show up in English novels in the later 18th century, and it's often represented not only as a characteristic of the novel, but as a necessarily written form. Unspeakable Sentences is the name of one kind of canonical critical work on FID. The idea is that no one can speak this aloud. That would be very unnatural. But Horsmanden not only predates these examples of FID in the novel, but he's using it almost invariably when he is taking down, according to him, the words of a deponent in a deposition. They're almost always a defendant or a witness recounting the words of a third-party conspirator. Obviously, we can't know to what extent Horsmanden is rendering that testimony accurately. I am pretty sure that he must have taken a lot of liberties, but the very fact that he chooses FID in that context is, I think, really interesting, if it is entirely kind of his authorial decision. And I think part of what it does here is allow a deponent to communicate the declarant's words, that is the third-party absent speaker's words, without being tainted by them. And that matters because we're talking about a conspiracy investigation. It's a matter of life or death, actually, not to be associated with the person whose words you are summarizing. And when you're recounting kind of a confidence about an alleged conspiratorial plot that someone has related to you, the listener's natural question is going to be, why did they tell you? Why did they let you in on this secret, this private information, right? Are you part of it? So I think FID, one of the things it does is allow the speaker to render the declarant speech accurately, but from a distance, and kind of to place the speaker's own credibility in the background, and have sort of foreground the declarant's credibility. So this is kind of my second argument, is that it's no accident that this early version of FID showed up in the context of a conspiracy prosecution. And I think rendering the conspirators' words accurately was especially important, or I should say rendering them kind of in plausible detail, was especially important for witnesses and for jurors, because the alleged conspiracy here didn't have much to do with overt actions, or I should say it was about the setting of the fires, but there was basically no forensic or eyewitness evidence that would have tied these specific individuals to those fires, right? What the prosecutor had were reports of conversations at which the conspirators allegedly made plans, took oaths. They made a big deal about these oaths, cemented their solidarity with each other. So what matters what evidence of the relationship between the conspirators, and that just proving that you're part of that network is enough to make you guilty of the fires in kind of the logic of these proceedings. So the relationship, I should say, was often captured best by kind of details of diction and grammar that reflected the declarant's attitude toward the conspiracy and its members. That's part of what I'm arguing here. And even today, actually, the reported speech of a member of a conspiracy has a special evidentiary status, which we can talk more about later if you're interested. But the gist is that the kind of secondhand statements of conspirators, which in a prosecution for a different crime would be labeled hearsay, can be admitted as evidence. And one of the justifications for this, one of many that have been offered over the centuries, articulated by the US Supreme Court just a few decades ago, is that, quote, conspirators are likely to speak differently when talking to each other than when testifying on the witness stand. So in other words, there's something about how a conspirator speaks, not what he says, but how he speaks to his partner in crime that is especially revealing or inculpatory. And I think that is part of what makes FID a useful tool there. And then the kind of last point I want to make quickly in closing, it's sort of a bigger swing, but I want to toss it out there so we can talk about it. So I mentioned hearsay from the Anglo-American common law of evidence. It's an out-of-court declaration by a third party, not himself on the stand, that is submitted for its truth. If such a declaration is submitted for another purpose, as circumstantial evidence of the defendant's state of mind, for instance, it is often admissible, but not if it's submitted for the truth of what's being asserted in the statement. And that distinction wasn't always legally salient. So in Blackstone's commentaries, that's about 2 decades after the journal, he states that any evidence of a discourse with another is inadmissible, regardless of whether it's submitted for its truth or any other reason. It was only in kind of the late 18th and early 19th century that this truth of the matter asserted component came to be part of the definition of hearsay in the doctrine, right around the time that FID was taking its canonical form. And that is a temporal coincidence. It's not anything to hang a causal theory on. But I think that Horsmanden's use of FID helps reveal that it has a property that's useful to the hearsay rule, which is sort of separating the propositional content of an utterance from its style. And I can talk more about that in a little bit, but just to close on 2 kind of broader points, I think the pragmatic pressure that criminal prosecutions place on the language of vulnerable defendants and witnesses can be a source of linguistic innovation. And I'd be interested to think more about other instances of that with you guys. And that linguistic innovations can render certain legal concepts more thinkable than they would otherwise be, more kind of natural and easy to work with. So that's what I have.
So thanks for a wonderful paper. I have lots of questions. I'm sure the other people present do too, and perhaps some of those watching by Zoom. Maybe I'll just ask a quick question about, so you raised this point that there's a comparatively recent US Supreme Court case that observes that, what someone's going to say on the stand differs from what they probably said at the time. I'm just curious, or specifically with respect to conspirators and co-conspirators. So I'm just curious whether we find any sort of contemporaneous recognition of that in, say, the 18th century.
So not that I know of in the context of conspiracy, but one of the places where I'd like to expand on this argument a bit is thinking about the particular, I don't know if genre is the phrase, but the kind of pretrial examination and the norms of kind of questioning during those conversations. This is something that Barbara Shapiro has written a lot about. In those contexts, the kind of guides that were given to justices of the peace and so on in the 18th century talked about the manner in which someone answers questions a lot, right? That's distinct from, the issue of hearsay, because this is someone you're speaking to directly and you're kind of getting those clues through their own testimony, presumably. But so insofar as that was even on anyone's kind of radar as a kind of something that was evidentiarily useful, right? Not just kind of that might actually contribute to a finding of the truth of the matter. I think that is like a little premonition of that, maybe.
Yeah, yeah, absolutely. Let me just see if anybody else would like to jump in, please. We'll take Elise. So Anna, you've already unmuted, so please go ahead.
Me first?
Yeah, yes, please.
Yeah, well, thank you. That's a very interesting paper. I read it and was very impressed. But I have a few questions actually about the way you understand free indirect discourse. And I'm not convinced that the quotations that you have really work for you, because I think the one that you just read, actually, I don't see the difference between your understanding of free indirect discourse and indirect speech. To me, this reads like indirect reported speech, not free indirect discourse. And that actually brings me to a larger point. You seem to be saying that free indirect discourse somehow is a tool for certainty, for sifting things through. You just use the word, you can separate content from style. Right, that you said something about how one of these witnesses can report the speech without being tainted by the words. But the one of the most kind of famous examples of free indirect discourse is Madame Bovary. And when Flaubert was put on trial, the problem was precisely the merging of the perspectives, so that the prosecutor and the defense attorney were pointing to the same sentences and saying, one was saying, this is Flaubert's perspective, and the other one was saying, this is Emma's perspective, right? So, and so I don't quite grasp how free indirect discourse can be a tool for clarity, while sort of traditionally it's understood as a tool for ambiguity, that it's a vehicle for uncertainty. You can't quite separate one perspective from the other. So that's the question I had for you.
Yeah, great, thank you. So I guess on the question of clarity and ambiguity first, I didn't want to quite communicate, and if I have, I will kind of walk it back, that this was a tool for kind of certainty or clarity necessarily. I think what I'm trying to get at is that it's a sort of strategic kind of formation that does two things at once that the witness or informant in a conspiracy trial needed to do. Doesn't necessarily do it perfectly, but the one thing is the kind of distancing thing that I was suggesting, right? Avoiding this kind of taint. But the other thing, which I talked less about just now, but I think is equally important, is kind of giving what seems to be an inside look into this kind of private space of the conspirators' conversations, right? And to be useful witnesses, the speakers here needed to do both. They needed to seem to be providing new and privileged information while they were providing it in a way that didn't necessarily implicate them, or not fully. And so I think that I definitely take your point about the Flaubert trial, and I think that in some ways the novelistic FID in the language of a narrator, that that same kind of dual function, insofar as it's there, this kind of glimpse into the interiority of someone else without fully endorsing it exactly, is serving kind of a different function that has to do with the fact that we're in this fictional universe, that this is from a narratorial perspective that is presumed to be omniscient, and all that kind of, those kind of differences. So I think that is what I would say in response to your second question. And I hope I didn't freeze just now. There we go. In response to your first, you're absolutely right that it is. I mean, this is reported speech, right? It's not people talking about what was going through the mind of one of these conspirators. I think in early not early, but in 18th century English novels, I think that there's often kind of a bit of seepage between the category of kind of indirect reported speech and FID. If you look at the thing that comes to mind, since we're thinking about criminal law, is like Caleb Williams or something like that. And I think that what I'm interested in is, with the awareness that like calling this FID is maybe problematic, I do think that that it's useful to kind of see this as a moment in kind of linguistic development that came to resemble something that we would consider FID now. And given that it is reported speech, I think retaining so many of the characteristics of the original diction and retaining them in this kind of selective way where it's in the embedded speech of the opponent rather than in the voice of Horsmanden himself as narrator is a peculiar move that is sort of suggestive of some of the affordances of FID.
I think you're right about the second your long quotation. I think there's something interesting going on there between that seepage that you're talking about. The long one, like really long, several lines. Yeah, there are some sort of dialectical features there that are preserved and some sort of lexical registers. But to my mind, the first quotation is just it's just indirect speech. That's just recorded speech. Anyway, just wanted to say.
No, thank you. Thank you. That's very helpful.
Elise, please.
So I just very quickly, because I know we have to move on. I was just wondering, and maybe this is more of something to talk about later. What did the trial records of the time look like in terms of reporting speech? Because in all of the records that I worked with, it's all reported speech. There's never any quotations. Like very, very rarely you'll find a quotation everybody's very excited about, because we never get those. It's all indirect speech. And that's because it's not in the language that's being recorded in, right? That the trial is taking place in French, it's being recorded in Latin, but people are testifying in English. And so it's being recorded as indirect speech. And that continues for a long time. I don't know if that's standard I don't know anything about 18th century records. I don't know if that's standard or if it's now standard to use quotations. Because it seems like that might be a good point of comparison if you want to talk about how this might be something more like free and direct discourse rather than reported speech.
Definitely, yeah. So this is something where I think Simon knows way more than I do. So I hope he will save me if I say something wrong. But yeah, I think it was standard to use reported speech rather than quotations. That's my impression. And most of this Horsmanden text is taken up with like long indirect passages about the deponent said that on such and such a day he did whatever, and he saw so-and-so talking to whoever, and they said this. So yeah, I think that the standard for witnesses was not to present their speech in direct quotation. I think one of the oddities of, at least I think it's an oddity, pending further kind of comparison of this conspiracy trial, or these conspiracy trials, is that the reported speech of witnesses, defendants, informants, itself contained a lot of reported speech, right? That these people had to refer to third parties' conversations as like the primary sort of evidence of guilt that was available, was kind of talking about how this person said that he would burn this building down at this meeting in this tavern at this. So I think that, yeah, that if there is something unusual happening here, it would be coming from that kind of secondary embedding that is within the typical embedding of kind of trial proceedings as reported.
Yeah, and I think the conspiracy thing is especially important there, because you might also be interested in sort of approval records earlier than that, because they're all approvers or people who turn king's evidence, and they're all about, he said he was going to do this and he said he thought this, and so you might find just sort of like the inheritance of this stuff that you're talking about here.
Yeah, that's really interesting. Thanks.
Yeah, that's a really wonderful point, Elise. Thanks for raising that. I just wanted to offer a very brief thought, which you can respond to or not as you think best, Hannah. So it strikes me that the point that Anna raises about blending, merging. So as you know, this is something that Roy Pascal discusses in the dual voice, and so it's possible that Pascal's discussion might be helpful in managing that point.
Yeah.
Another reason why I think that's a useful or intriguing book to go to, given what you're describing, is, as you'll remember, one of Pascal's points is that we can have FID of groups as well as individuals. And in the context of conspiracy, I think that's quite an intriguing thought. So the examples that you give, if I remember correctly, all have to do with individuals. But it's a sort of interesting thought that you could use it for groups. And so the question sort of arises whether it actually is in some way being used as the FID of a group in the examples that you're looking at.
Yeah, that's a great thought. Yeah, I will definitely look at that Pascal again. And just a quick thought on FID of groups. So I think there actually is a little instance of that in the text, but oddly it is of the community of sort of white, upstanding New York citizens, New York City residents, rather than of the conspirators. Very early on, one of the ways that the conspiracy kicks off is through this white woman overhearing a Black man talking about the fires with another Black man, or I think two others. And that's a direct quote, one of the few in the text, that then, as she reports it, gets sort of not laundered, but kind of reframed in the kind of collective discourse. And we get a version of it that is sort of in this quasi-FID, vocalizing the conspirators, but in the voice of the white community. So it's a very peculiar moment that I was thinking I need to talk more about in the paper, and that would be a great critical work to go with that.
So thanks for a wonderful paper. We're off to a great start, much appreciated. Our next speaker is Anna Schur, who has her PhD from UC Davis in comparative literature and an MA from Leningrad State University. She is the author of Wages of Evil, Dostoevsky and Punishment, and The Letters and the Law, Legal and Literary Culture in Late Imperial Russia, both from Northwestern University Press. Her work has appeared in Slavic Review, the Russian Review, East European Jewish Affairs, Russian Literature, Law and Literature, and Slavonic and East European Review. And her current research focuses on notions of fact and historical authenticity in fin de siècle Russia, and she'll be speaking today on higher justice and Russian law. Please take it away.
Thank you so much, Simon. I also have to thank you for giving my paper a title. It was very wrong of me to send my draft without a title. So thank you for coming up with this title. But I want to say a word about the title before I move on. I just want to be I want to be clear. I'm not writing really on law, not on how it was practiced and not on how it was theorized. I'm not even writing on a legal concept. I'm just writing on broadly shared and deeply embedded cultural attitudes toward law. So I don't know what the second term will be in the end, something like legal culture or legal consciousness, something like that. Higher justice, however, is something I'm writing on, so that's good. But I want to say something here as well. It's often sort of sold to the reader or to the public as some sort of very lofty concept. This trope of higher justice. And I want to say in the paper that it's not an innocent concept. It's not even a neutral concept. And we know that it's neither of those things from its high concentration in the discourse surrounding the annexation of Crimea in 2014 and onward. And in this discourse, this utterly sort of thuggish land grab is presented as a fulfillment of this higher justice. And very often, it's less a foil, is not even sort of it's not described. It's just assumed. It's implied, and the lesser foil is justice worked out in the framework of the law. So it's legal justice or just simply law. So in other words, higher justice figures in this discourse as justifies really brutal, thuggish politics as triumphs of morality. And that's what I wanted to write about. I wanted to trace this concept throughout, history roughly. And incidentally, the reason why it's not necessary to even spell out what that lesser inferior foil to higher justice is because it is such an old trope. It's perfectly recognizable and very compelling in the Russian context because it's been around for a very long time. So that's what I'm tracing. I'm tracing the history of this, a history of this trope and its connection to the discourse of Russian national identity. So these two things, as it were. So, and then I begin with something, with a medieval text. It's an early text of Russian, not even, it's Slavic spiritual literature and homiletics, and it's called The Sermon on Law and Grace. It was written by the first non-Greek Metropolitan of Kiev, who was sort of celebrating the people of Rus, this kind of concept that predates Russia, definitely. And it sort of, he draws on Paul's contrast between law and grace right there in the title. So perfectly familiar antithesis. But the reason why it's interesting to me is that for the first time, he makes this antithesis into a framework for eulogizing these new Christian converts, the people of Rus. And then ever since then, this link between the spirit of Rus and the superlegal categories of grace and truth, they have been around, kind of in modified form. They would appear here and there, but they reappear with a special sort of force in the 1830s in the discourse of this group of thinkers who were called Slavophiles. And this was essentially a movement that was with roots with German Romanticism. And they were the ones who essentially introduced for the first time the thesis of Russia's special way. And they formulated the construction of Russianness that persists to this day. So they did it through this kind of series of oppositions, and there are many, but I will only touch briefly on those that are relevant to us today. So the West is kind of constructed as despiritualized and overly committed to external forms, and that means above all legal forms. So it's juridically minded, it prioritizes law over dictates of morality, and therefore Western justice is forever hollow and superficial and sort of inferior. And then on the other side, you have the Russian people who are sort of, they are idealized, it's sort of endowed with this non-juridical, non-formalistic worldview that emphasizes the inner meanings of things and relationships, and this word inner is central. Everything is inner. Everything that's valorized is inner, and everything that's not is somehow external or superficial, something like that. So the Russians are they possess some sort of special sensitivity to justice, understood in that robust non-legal sense. And all of that is an expression of some sort of special spirituality. And so even though the Slavophiles do not often use the expression higher justice, they all talk about inner justice all the time. And I treat it as an analog to higher justice. So, Slavophile sort of lost in that contest of ideas in the 19th century. They really lost to more Western-looking people. However, that one strain of their thought, that romantic anti-legalism, proved extremely influential in the Russian context, and it really became part of the Russian cultural imaginary. It impacted social thought across the board. It shaped the views of the Russian intelligentsia for generations to come. The Russian intelligentsia in the late imperial period on the right and on the left was extremely dismissive of the value of law. At best, they understood law as some sort of instrument for achieving some goals, never for its own sake. And that sort of mentality impacted even legal professionals, so even they were susceptible to these sorts of ideas. I'm saying in the paper, and also, this draws a little bit on the book that I recently finished, that all of this had an impact on the kind of tenor of the Russian courtroom. It was very moralistic. It could have encouraged relying on purely subjective instinct in arriving at the verdicts. The word conscience was everywhere, and conscience was understood, pretty much in ethnic and religious terms quite often, rather than some sort of, all-inclusive universal property of humanity. So I spent quite a bit of time in the late imperial period, but then I also take it into the early Soviet context. And even though there was a huge break, obviously, between the pre-Soviet system and the Soviet system, and historians debate how much continuity is there. But one thing that's pretty clear to me is that moralistic tenor survived, even though the early Soviet justice completely dispensed with written law, just altogether. For a few years, there were no written laws. So all the decisions were grounded in revolutionary conscience and revolutionary morality. And even though morality was now the property of class, so it's a sort of a class attribute, but the moralistic tenor of the courtroom endured. And then I take it to the late Soviet period, and then I'll finish the paper somewhere in the present. But I want to conclude, because I think I'm running out of time. I want to conclude with one point and the point is this: even as I trace this rhetorical trope, I also want to say something about the Russian literary tradition, because really no one has done more to entrench this concept in the Russian cultural imaginary than the writer. You take almost any 19th century Russian writer, huge names, Dostoevsky, Tolstoy, Gerson, Saltykov-Shchedrin, or big Soviet names, Pasternak, Solzhenitsyn, huge names, but also lesser known names. They're all sold on this idea. Every single one of them, contemporary writers as well, both pro-regime writers and sort of, people, let's say oppositionists, writers, and even scholars. And because prioritizing morality over law contributed to Russian literature's, very weird reputation of being considered as somehow especially humanistic and committed to moral absolutes, I want to say that maybe there's something dangerous about this kind of moral fundamentalism. And higher justice, this concept kind of allows us to see that darker side of this total refusal to accept something positive about actually building a society on on the foundations of law, right? They all have these sort of dreams of non-juridical societies, and then, Russia keeps ending up in some sort of nightmare. So anyway, that's what I'm writing on.
Well, thanks for a wonderful paper. You've raised quite a lot of issues. Maybe I'll just try a very short question. So it strikes me two other potential contrasts: letter of the law, spirit of the law, and law in the books, law on the ground, or law in the books, law in practice. So I'm just curious whether the distinction that you're exploring, whether you might want to say something about how it relates to those. Maybe those are actually not useful ways of understanding the contrast that you're getting at. One thought is that normally when we talk about letter of the law, spirit of the law, we're not talking. So the spirit is not an alternative to, but like what the written law really means to achieve, as opposed to what it missed or overlooked in its written formulation. So it strikes me that at the very least, although we have this term spirit, which might in some ways connect with what you're describing as inner, the mapping is not complete.
Well, I mean, a couple of things. One is that I think that a professionally trained 19th century, let's say, lawyer, let's just stay with that, because this was the time when Russia, I mean, many historians agree that this was the time, like from the 1860s to 1917, this was the time when Russia came closest to the rule of law ideal. It never reached it, but at least it was trying. So those people, those legal professionals, I'm sure they did draw that distinction between the spirit of the law and the letter of the law. But remember, I'm not writing about how they practiced. I'm writing about how the image of the law that they sold to the public. And the image of the law that they sold to the public simply didn't have space for those kinds of distinctions. Law was sort of, I mean, I think there's a difference between how they practiced and, let's say, the types of speeches that they kept selling, collections of speeches that they kept selling in huge numbers. So these are sort of distinct things. In the courtroom, they probably understood, and I'm sure they did what they needed to do. I mean, a lot of it was opportunistic and driven by pragmatic needs and so on. But the image, the sort of the cultural image of the law that is, that they socialize the public into, it's too, I don't know, it's too nuanced somehow. Right, there's this sort of higher justice. It comes from your heart, as it were. It's this, it's instinct, it's gut. It's not that, overly intellectual distinction. This is what the law says, and this is really what it means. It's nothing like that. It's much more straightforward somehow, and also, again, moralistic. They want to sell the image of the law at best as some sort of a tool for improvement, moral improvement somehow. This is, I think, the best we can get from the cultural discourse. Right? I mean, scholars are writing their things, and they do all sorts of nuanced stuff. But what the public reads and what it craves and what it kind of keeps getting reaffirmed in is that other view.
That's great. Thanks. Elise, please.
So this might be retreading what Simon just said, but I was wondering if even in this sort of cultural space and in this kind of outward facing language, if you are encountering or looking at any disagreements about what the higher justice would tell us in this particular situation. Is there any instance in which there's sort of a decision to be made or a choice to be taken, and there are actually two voices saying different things about what the higher justice here would entail?
Well, yeah, I mean,
or is it only ever sort of a univocal, a sort of univocal thing?
well, so let me give you an example. There's a blood libel case, right, tried by someone who just a year ago in a very, very famous scandalous case was kind of screaming for that higher justice to be realized. Forget the law, forget that the criminal confessed, forget all of that. None of this is in question. Give me this, yet forget the law, just follow your conscience. A year later, he is trying a blood libel case on the outskirts of the empire, right before a Christian jury. And he says, no, gentlemen of the jury, you cannot follow your conscience here. You have to come to a conclusion that we can actually understand logically. And, if this goes to a superior court, we need to be able to trace your, how you thought about it. So, of course, they understood that higher justice has this very dark potential, that his Jewish clients would not fare well, right? If this Christian jury relies on its gut instinct, of course they will all be convicted. So he gets that. So in these cases, of course, there's there's the law and there's some sort of procedure, and you need to, well, the procedure is not something they're concerned with at all. But you have to deliberate with some, consideration for facts, and you need to be able to explain how you arrived at this conclusion. So he's saying things like that. In other words, what I am getting at is that it was pretty, in the context of specific trials, they were pragmatic and they knew how to get to the result that they wanted. So they wouldn't call for higher justice if they knew that it would harm their clients. But the sorts of speeches that come out, and get republished, to this day in numerous editions, very often will conclude with some sort of appeal to the jury, or follow the voice of conscience. That's what sort of, that's the image they are promoting, is the point.
Thanks, Hannah, please.
Yeah, so I'm afraid I have a question that is, I think, both presentist and provincial, because it has to do with the contemporary US, so apologies. But while I was reading this wonderful piece, I kept thinking about a recent incident where a justice of the US Supreme Court flew over his vacation home a flag reading An Appeal to Heaven, which was associated with the US Revolution, but came to be associated with kind of white Christian ethno-nationalism. It was one of the January 6th insurrectionist kind of rallying cries, and it has to do with this idea of law as it exists in kind of the secular world is inadequate. We appeal to the higher justice, right? So I guess I have two questions related to that kind of little echo. And one of them is just sort of, do you see this discourse in contemporary Russia kind of intertwining with, or at all kind of contributing to participating in this kind of global sort of ethno-nationalist moment that we're unfortunately in, if we're in it? And then the other question has to do, I think, with the revolutionary context. And I'm wondering, you mentioned, this is a discourse that lawyers and legal professionals kind of direct outward toward the people, right? And it's part of kind of the rhetorical image of law more than the practice of law, potentially. And one of the things I'm wondering is it actually possible to sort of have this understanding of higher justice in a kind of normal law context akin to like Kuhnian normal science? Or is this like something that kind of is necessarily associated with these like revolutionary upheavals? It sounds as though rhetorically it is kind of foundational and supposedly part of kind of how any routine case comes out, is through this kind of conscience, searching of the conscience, at least in the kind of 19th century instances that you're writing about. But I'm wondering if this is a case where kind of, if you think there's, would it be possible for that to kind of exist as kind of a part of the routine functioning of a society, or is that like purely a kind of transitional or revolutionary concept?
So, I mean, Russian ethno-nationalism is just utterly out of control by now. I mean, they are shading into fascism. I mean, actually, some people claim it is a, purely fascistic regime now. I'm not going to go there. I'm not qualified to make those kinds of distinctions. But and I think it is a manifestation of the global turn to the right. If I understood what you're asking. So they kind of know it, but I think they would still see themselves. I mean, that's part of what's going on in Russian politics now. I mean, it's total isolationism, right? I mean, they feel disconnected even from the global right. So in that sense, I don't know. I think they would emphasize that specialness that was first articulated by the Slavophiles. I mean, there's the total resurgence of neo-Slavophile ideology now, except that it's more vicious and more violent and more darker, more perverse, much more isolationist than before. So it's sort of Slavophilism, more poisonous, but on steroids. So I think they would still see, the Russian way is somehow special, and the higher justice is also special. I mean, it's so I don't know if they would they would probably be more receptive to Alito's flying the flag than to some, I don't know, lefty liberal justice, but fundamentally they're on their own. And the second thing, can that be some sort of foundational idea? I mean, I'm trying to say in the paper that it's a very perverse way of thinking about ordering a society. And so I think that's what I would say. I certainly don't think that any kind of this ethical fundamentalism cannot bring anything good. And I think Russian history proved it time and time again. So that was the spirit of the paper. I don't know if it came out that way, but that's what I wanted. So I wanted to say, maybe less histrionically than I just did now, but that's the spirit.
Thanks. That's wonderful. So if there aren't more questions, just want to we'll go on to the next paper. Thanks very much, Anna. So our next speaker is Daria Bayer. Daria is a lawyer, philosopher, and theater maker. She's currently a postdoc in criminal law at the Martin Luther University of Halle-Wittenberg. She has a theater collective and tries to bridge the gap between the reality of law and philosophical utopias by means of theater. She has partly written her PhD, Tragödie of Law, as a play and staged it at Hamburger Sprechwerk. And her most recent premiere in April this year was a play about the Cum-Ex scandal, which took place in the City Hall of Hamburg. Daria is speaking today on truth, trial, and tragedy. Thank you very much.
Yes, thank you so much for giving me the opportunity to present some ideas here. I want to start to say that the ideas that I will present now, I developed them roughly about 2 years ago at a conference about show trials in Münster, and I'm really happy to have the opportunity now to pick up on them. So let me start by some preliminary remarks on methodology and terminology. My aim in this paper, as I'm sure you have seen in the abstract, is to make an argument for the jus puniendi of international criminal law. I want to show that the facts established in criminal trials, especially before the ICC or special tribunals, can play a limited but an important part in establishing a common global narrative. And for this, I will investigate into the role, function, and claims of truth in international criminal proceedings, as well as in German criminal law. You might wonder why German law, because A, I am a German lawyer, so this is the system I know best, and B, because international criminal law doctrine can be said to be strongly influenced by German criminal law dogmatics. For example, the doctrines of Roxin or Radbruch after Second World War II. Of course, we can debate about that, whether you think this is a good idea. So my argument here, just to recall, is based on three assumptions. Firstly, that the legitimacy of criminal proceedings is linked or intrinsically connected to the validity of their self-claims of truth during investigations and trial. Secondly, that from this follows that if international criminal proceedings can validate their very high expectations of material truth, then they have also a strong claim of legitimacy. And thirdly, that if international criminal proceedings can make a strong claim of legitimacy, then they can become an important element in building a world community. So let me clarify that I do not wish in this paper to aim at the question of, for example, what the purpose of international criminal trials is, because this is highly debated, and whether it is the acknowledgement of the suffering for the witnesses or retribution or prevention or all of the above. However, I claim that seeking truth is one important element of any democratic trial. So you can debate about how important it is, but I think it is an important element. And also I want to clarify that there is a difference between the narrative established by the court and how this narrative is perceived by its target audience. So there is a difference between the true facts established by the court and then the question, especially in criminal proceedings, whether the target audience may accept this narrative as the true fact. So this is a problem of communication of truth that, in my opinion, comes after the question of the legitimacy of the trial. So after having clarified that, let us look into provisions of criminal procedure and what importance they place on truth. Seeking truth seems to be of utmost importance to criminal law on a national and on an international level. According to paragraph 244, para 2 of the German Criminal Prosecution Court, the court is bound ex officio in order to make a judgment to investigate the true facts. The same goes for proceedings before the International Criminal Court. According to Article 54, number 1, letter A of the Rome Statute, the prosecutor shall establish the truth. Under both German law and the Rome Statute, the prosecution and the courts are bound to investigate incriminating and exonerating circumstances equally. So the court must at the same time respect the rights of the accused, letter C, while researching the true facts. So already from this, we can draw some first ideas about what truth in criminal law entails. First of all, the quest of truth in criminal law is always a functional one. The prosecution or the courts should investigate the true facts in order to make a judgment based on those true facts. So judgments themselves are never true or false, but it's just the facts that are true or false. Also, criminal courts investigate the true facts only if they're relevant, only insofar as they're relevant to the case they're trying. So truth in criminal law is always limited by the jurisdiction over the case and the case that is tried. Furthermore, the premise of truth serves as legitimating the exercise of sentencing state power on the one hand, and on the other hand, it serves as limiting state power. The idea behind it is that a trial that prescribes itself to finding the truth is a just trial, a trial that wants to give justice to the victims and at the same time give the accused the possibility to prove that he or she has been accused wrongly. In the sense, we can positively state that truth in criminal law can, by definition, never be absolute or historical truth, nor truth by all costs. We may wonder if that is even possible to establish absolute truth, but that would be a deep philosophical or historical inquiry I can't make here. Furthermore, we can already see from that truth in criminal law is always contingent of the rules of evidence and thus contingent on the political system that defines those rules of evidence. So what kind of truth is produced in criminal law? Criminal law always looks, at least when it comes to establishing the factual side, necessarily to the past. We can only hold an individual liable for an act she has already committed, not for something she might commit in the future. Even if we judge somebody for an accounted crime, we judge the manifestation of the accounted crime in the past. However, we are looking at this act from the perspective of now. In the sense, already Benedetto Croce said in 1917 that every true history is contemporary history and written from the point of view of contemporary preoccupations. And the same is true for criminal law, especially international criminal law, where often a trial of the responsibles only becomes possible after the ones in power have been defeated. So we try to look to establish what happened in the past from the perspective of our contemporary thoughts and might hope by this back look to prevent such atrocities in the future. So it is clear for all materialistic legal scholars, but I still feel that I have to say it expressively again, because at least in German criminal law, and I would be interested if you have that as well in your jurisdictions, criminal lawyers tend to think that the truth established in a criminal trial is absolute truth. But for me, it is clear that, as Foucault has already put it, the legal process of finding out the truth can never be thought to be outside the power, but is produced by the political power in place. Foucault showed this oppressively on a hegemonic reading of Oedipus Tyrannus, where he identified Oedipus' quest for truth as the first naissance of the criminal trial, because according to Foucault, for the first time in Greek tragedy, did the powerful hear out the testimony of the people, also of the normal people, and in the end, the democratic knowledge defeated Oedipus' stubborn blindness about his own perpetration. However, I think a modern theory of international criminal law cannot simply and does not simply end at an account to say that every truth is dependent on political powers, because that would open the door for relativistic accounts of history or historic revisionism. Rather, and I also read Foucault's Oedipus interpretation this way, liberal democracies aim to come as near as they can to produce a narrative of what really happened, by giving every testimony and thus every voice, in theory, the same weight. Although, as for example, Miranda Fricken has shown, some people's testimony is weighed less by courts than others, especially women or POC, for which Fricker coined the term epistemic injustice. So in the sense, aiming at truth in democratic criminal proceedings means aiming at hearing out all witnesses and the accused in the same way and reaching a conclusion about what happened only after having considered all admissible evidence comprehensively and equivalently. In that sense, we can say in a liberal democracy, criminal truth is democratic truth because it follows the principle of the middle, as Foucault names it, or of balanced evaluation of evidence. Now, returning to the ICC, the challenge lies in overriding counter-narratives of the accused to try to attack the legitimacy of the court and claim themselves to know the truth. And how can we do so? That is the main question I'm looking at the moment for the paper, and I'm really happy to hear thoughts on that. As a starting point, one might look to criteria such as responsibility to the rules of evidence, fidelity to factual record, logical consistency, and coherence of argumentation, to cite Helen White. We might also learn from past cases, such as the trial against Milosevic, and ask whether it might be helpful to concentrate several indictments in one trial to establish a current narrative about what happened. But most importantly, I think we're being realistic about the limited scope of historical truth that can be produced in the form of criminal law. We shouldn't lose hope in the idea of the ICC and its important role in aiming at the truth. Thank you very much.
Thank you. That was wonderful. So questions? Anna, please.
I'm dying to know where this excerpt from the play comes from.
Daria, you're still muted.
Sorry, you mean the play in the abstract?
Well, you have something that's called Prelude, and then
Yeah.
what does it
Yeah.
come from?
It's from my play.
I want to read your play. Can I read your play?
Yes,
Is it
sure. It is in German, so I
Okay.
translated it. But I can send it to you.
Sure. I'd love to.
Yeah, and I want to work actually on an English version of it. Because
I definitely want to read it.
yeah, but maybe I have to explain that I wanted to, oops, I have to stop my clock, that I wanted to make a bridge to my play as well, but in 10 minutes I was just saying,
Well,
it
here's the
didn't
opportunity.
yeah, but I'm happy to send it to you.
Okay. Okay.
Thanks. That's wonderful. Maybe I could try a question that in a way links what you said to Anna's paper. So you were sort of asking about lawyers' views of truth as absolute or not. And it strikes me, and others can tell me if you share this view. I tend to think that in the US system, at least, lawyers don't believe that facts as established at trial are absolute, but there's a public perception that truth is absolute in the sense that you were describing. So far from it being a professional attitude towards truth, I tend to think that it's a popular or lay attitude towards legal truth. And I guess I'm curious whether others agree, and if so, how, what significance that might have for the argument that you make.
Yeah, thank you very much. That is a good question. So I think, at least from my perception, it's different in Germany and it's different for German lawyers because you have the civil law system and because we have, and you don't have that, right? So you don't have a section like paragraph 244 where the court is bound ex officio. So without anybody asking for it to investigate the true facts. And I think this tends for criminal lawyers to believe that actually courts can investigate the truth without really asking what truth is. So, and we had a debate in Germany, and this is like also where my interest came from, about the reopening of the trial. I don't know how you call it. So after trial is completely finished, it has gone through all the stages, then you can't appeal anymore, but you can reopen a trial under certain conditions, and they are extremely limited in German law. Now, there was the attempt to make a new law called the Law of Material Justice, saying that for some crimes like murder, but also crimes under the Völkerstrafgesetzbuch, which is the criminal code of conduct for international crimes, that there you should be able to reopen the trial if there is new evidence that comes later. And the idea behind that is that you can know the absolute truth by a trial. So, and this is why I felt, and I'm really interested to know your thoughts on that, because if I'm writing like for the Modern Criminal Law Review, which is not a German law paper, of course, I want to know whether my remarks on the German debate are like relevant for you, because here I feel like, yes, I have to stress this point, but maybe for you, I don't even have to stress that point because it's so clear.
Hannah, please. Yeah.
Yeah, well, just to pick up on that, I think they are quite relevant. What you just described is reminding me of in the US, ongoing debate, which it feels shocking that it's a debate on the relevance of actual innocence in the course of like the criminal appeals process and the habeas process, which is after that. And this is not an area that I know a ton about, so I don't want to go too deep into it. But basically, the idea is, there is a point, at least theoretically, where procedure runs out. But should there be evidence of actual innocence that emerges after procedure runs out, what is the appropriate remedy, if any, right? And so, yeah, just to say that I think it is quite relevant. Just to kind of pick up and maybe think a little bit more, because I was really interested by the suggestion that sort of in the ICC, you can see maybe one of the internal kind of weaknesses or pitfalls of the kind of sort of liberal democratic approach to the criminal trial, which is this opportunity for kind of historical revisionism to get the floor, right? Or for a kind of a version of historical truth that is totally unbound to, kind of anything we would consider truth to get the floor. And I guess I'm curious about, is the only way to kind of come back at that through sort of more procedure? Like, in a way, in other words, when you're dealing with a conflict on the level of something like this baseline kind of historical / material truth, it seems like, I struggle to think of a way to resolve that issue that doesn't actually come down to kind of some kind of internal set of procedures for validity. But that might be because, I am one of these like kind of Western proceduralists, formalists locked in. So I'm curious about your thoughts on that.
Yeah, thank you so much. So, I mean, what I read in my research was that there is the argument put forward that by all those procedural rules, actually the court cannot reach anymore its target audience. And this is why I said at the beginning, I think it's a different question. Like, I think we should look at the question of how we can establish the truth in the criminal trial by procedural rules. And then in a second way, deal with the question how we can communicate it. Because of course, from the outside, and I mean, this is like, I feel like a really interesting debate also in critical legal theory, like is like the democratization of knowledge. Is it done in this way that everybody can access that? Like, I read the criticism, for example, nobody reads 2,000 pages of judgment. Like, okay, so yeah, that's true. But still, is then like the good way to deal with that to make the judgments shorter so that everybody can read them? Or should we then think about, okay, we need to have the procedures to make sure, and maybe that's complex, but then we need to have a second mechanism that is maybe not even lawyers, or maybe lawyers like us, like lawyers working also in literature or culture, whatever, that have to translate that. Because I'm not sure that by making it easier, we really make it more accessible. We might also make it less true in a way. Is that the answer to your question, or did you?
No, that's really interesting. Yeah, thank you.
Can I?
Please, Anna.
It's really not very relevant, but I feel compelled somehow to say it. I just wrote a paper on how ideas about historical authenticity at the turn of the century, fin de siècle, Russia depended on the participants' politics. So they were reading the same memoir, but to some of them, the memoir was just it was a fake, and then to others, there's some sort of relationship to this higher truth. To others, they said, well, so what, that this is all factually inaccurate, it doesn't matter, it gets at some sort of robust sense of truth that we value as a nation. So it's very perverse in my opinion. And obviously, the ones that were saying, oh yeah, forget the facts, these were nationalist conservative narratives that were, they were the ones that were saying, I mean, we don't care what the facts are. We have this other sense of historical authenticity, and facts have no bearing on that. So anyway, not very relevant, but somehow it made me think of that debate.
I would love to read that paper if you want to send it.
To send it to you.
Yeah, could you share a link to it if it's available online? Could you share a link to it with all of us?
I don't have a link, but I can send it to the group. Yeah.
Please do. So two quick thoughts. One, and that's I think a profound and very significant point that actually leads to a discussion of truth, factuality, fictionality that I think might interest you, Daria. Professor Monica Fluternick has written extensively on all these issues, and not so long ago edited a sort of mega book anthology on discourses of truth, discourses of fiction, and ways in which they resemble and differ conceptually, linguistically. So I think that might be interesting to look at. Going back to a point that you raised before about the civil law, common law distinction, it strikes me that among the grounds that create debates about truth in the common law system, what one significant strand has to do with the role of cross-examination in confirming people's beliefs that the result of the cross-examination is a way of getting at truth, and people who deny that or feel ambivalent about it. And so I guess I'm curious about, I take it that cross-examination, as we understand it, isn't present in the civil law system, but that it's also not absent. And I wonder whether that might be a useful avenue to explore.
The cross-examination?
Yes, the role of cross-examination
Yeah.
in people's beliefs about its value or dubious value in getting at the truth.
Yeah, I think that's really interesting. I mean, at least I know it from my research on like sexual violence, and there the cross-examination is often what like crushes every testimony. Yeah, that's I made like notes. Thank you so much. And also I wanted to say to Anna that I sent my play, like the German version, in the chat. And that it's actually, so I would be also really interested to know your thoughts about it, because it is about Yevgeny Pashukanis, who was a Soviet linguist.
I'll have someone else read it, and translate it to me. So I don't, unfortunately.
Maybe I can just run it through DeepL, but like will not be a good, like I want to make a good translation and fall, but like there would be maybe a translation that you just can.
Well, that would be even better. But
a lot of like work on the language would be lost.
Yeah, Pashukanis caught my eye for sure. Yeah.
Thank you.
So that's all wonderful. Thanks again, Daria. So we're up to our final speaker for today, Elise Wang, who researches and writes about medieval literature, the long history of conspiracy theories and criminal justice. Elise is a Princeton PhD who now teaches at California State University, Fullerton. And I would be remiss if I did not mention this wonderful book, which Elise has just published with Oxford, The Making of Felony Procedure in Middle English Literature, which I urge everyone to go out and buy. And so Elise will be speaking today on Felon and Villain, the literary inheritance of felony. Please take it away.
I'm so excited to see the book. I have not actually seen a physical copy of it, so this is the first attestation of its existence in the real world. thank you so much for putting together this volume. Really good job, because I feel like there are so many resonances between our papers. Mine, I think, in particular, has a lot of resonances with Anna's work on higher justice. So I'll just get started. I'm going to be talking about the history of the category of felony in Anglo-American law, using primarily medieval evidence to talk about its initial conceptual formation. And my overall argument is that this inheritance can help us understand some of the idiosyncrasies of the category, maybe even now, although I'm not a scholar of contemporary American law. And this comes out of the book that Simon just plugged, which is about the medieval beginnings of felony procedure. And it's kind of about the different stages of the procedure. So it's about investigation and witnessing, the plea, sentencing, and how those stages were affected by literary ideas of guilt and evidence and proof. But I realized at the end I actually had more to say about the concept of felony as a category. And so that's what this paper is. So these ideas have kind of been knocking around for a while, but I haven't really had the opportunity to work them out. So I'm grateful for this space. Just sort of briefly, the felony as a category has this inherent contradiction in that it is both, quote, as bad a name as you can give a person or a thing. I did not think that Alito would come up twice in this conversation, but here he is again. He here is he's actually quoting Maitland, but that he wrote that in a decision. And so felony is the crime of which all other crimes are lesser versions. It's the or crime, but also it is only ever defined by its punishment, not by any kind of internal logic or principle. And so what Maitland observed of medieval felony is still true today. Felony can only be known quote, by its legal effects, so how we punish it. And any definition that would turn on the quality of the crime is unattainable. And this means that we get an interesting conglomeration of crimes under felony in modern American law. So, first-degree murder is felony, but as we have been recently made aware, so is falsifying business records and lying on a gun registration. So since far more felonies are committed than can be prosecuted, we really truly define the category by how we choose to punish it, which felonies we choose to punish. And so my interest is in how this concept functions and why we preserve it. And I think that has to do with its beginnings. That's kind of my argument. It began as a literary term. So felony was originally literary before it was legal. It was specifically an epithet for villainy, and it was almost always paired with either traitor or villain. And I think, so this is kind of the larger argument, I think we preserve the category, or we're hesitant to give it up, because it preserves a space in the law for these lay instincts about villainy. I was listening to Anna talk, and felony gives us space in the law for moral fundamentalism. And so I'm in the essay, I'm going to begin with kind of the term's first appearances in English literature, in Anglo-Norman and in English, and then its emergence in English law as a criminal category, kind of talk through these narrative beginnings. And this is all 13th century, just to kind of place us. And then in the paper, I'll move to the rise of the category in the 14th century, and take a look at two scenes of felony in 14th century literature to talk about some of the impulses that these literary scenes nurture nurtured in these kind of medieval stories of justice towards villains. What impulses did they nurture towards villains? How should we react to villains? How should we deal with them? That then made their way into the legal category. And specifically, I'm not going to talk about these at length now, but specifically impulse towards impulses towards speedy retribution, speed that is uncommon in the law, and a kind of moral certainty when it comes to felony, which I think in the law translated to a kind of flattening of the differences between felonies, such that they were all punished in the same manner, without regard to their specifics. And I'm happy to talk about that more later if you're interested. And then the last one is divine or self-inflicted punishment rather than human retribution. So in these stories of felony, there's always some sort of divine or even better self-inflicted punishment rather than human punishment. And so in this time, I just wanted to sort of give a little bit of that first part of the paper and focus on those first appearances in literature and the first use of felony as a criminal category, because I find that sort of movement really fascinating, and that's the basis for the paper. So felony's first appearance in English literature is in French. It's in Anglo-Norman Chronicles of Arthur. And so these are histories, chronicles, verging on romances about Arthur, about the history of England. And this is where we first encounter the term felony or felon. And a few things to note about the appearances, I'm going to read them, but first, they're never about single acts. They are always about identifying what role the character will play in the story. So a felon is a villain. If someone is called a felon, you know that they're the villain of the story. It's not necessarily connected to any particular act that they committed. And then second, it's almost always about betrayal. So in Wace's Roman de Brut, which is 1155, Mordred betrays Arthur, and this makes him a grand felon, so a great felon. And he also commits other villainies, autres villainies. So he, in addition to his being a felon, he also commits other villainy, indicating that the felonness is also a villainy. And then in the Chronique des Ducs de Normandie by Benoit, which is it's sometime before 1173 when he died, felon is used all over the place, and it's always as an epithet paired with another term, usually for traitor or villain. So there's qui felon est un traiteur, Sedouin, a felon, traitorous and felon, un homme cruel, a felon, a cruel man and a felon, felon, a villain. So they're all this sort of pairs, which to me also indicates that it wasn't a very common word at that moment, and you had to sort of explain it by pairing it with another term. And then it finally makes its way into English literature in Havelock the Dane, which is in about 1285. The villainous Goddard is a felon who plans a full, strong treachery, a treason. So again, it's the treason. And then a few years later in Handling Sin, Judas is a foul felon, the sort of original felon. And I like how Chaucer puts it. This is 100 years later, but Chaucer calls felony a smiler with a knife beneath his cloak. It's a very evocative picture of what felony is. And felony becomes a legal category around 1300, so about 100 to 150 years after these first emergences in Anglo-Norman literature, but right around the exact same time that it emerges in English literature. And my argument is that it takes this history with it. So Britain, which is a legal treatise, it's the first one to make reference to felony as a criminal category. Felony is described as, and I love this quotation, quote, any mischief which a man knowingly does or procures to be done to one to whom he pretends to be a friend. So first, this is obviously not a legal definition. The subsequent prosecution of felony makes it clear it's not just any mischief that it's a felony. Nobody prosecutes throwing water on someone as a felony. So that it's more gestural than anything. And then, you know, in any case, how would the law propose to define friendship, much less the pretense of it? So this is much more of a gesture towards a sense of felony rather than a specific definition of it. But this is how it first enters the kind of legal lexicon. And what strikes me about this is that it's not just clearly drawing on this literary usage, which is, you know, a felon is a villain, a felon is a traitor. It itself is also narrative. This definition has narrative embedded within it because a betrayal is not just a character trait. It entails both a past and a present, right? A past in which the person was trusted, and then a present in which the person betrayed that trust to one to whom he had pretended to be a friend. So there's this pretense, this past trust that is betrayed in the present. So it entails a story that unfolded over time. And so this is kind of the first section of the essay where I'm establishing the literary beginnings of the term. And then I show its continued influence, the literary influence over the 14th century, which is really when the procedures to prosecute felony developed. That's when it became sort of a commonly prosecuted crime. And I want to end a little bit with talking about the endurance of this category, even though it is incoherent as an assemblage of crimes. It doesn't have any sort of internal consistency to it, but we are very reluctant to give it up. And it's in particular, I think, in the collateral consequences, the permanent collateral consequences of felony, like disenfranchisement, loss of social services, things like that. We really are preserving this space for thinking about felons as villains, because villains don't get good endings, right? The villain doesn't get to repair their relationship with the community and pay their debt and come back. A villain is gone. The evil stepmother has to be she can't ride off into the sunset. She has to be punished at the end permanently. And I think that the category in its indeterminacy preserves that place in the law.
Well, thanks. Thanks for a wonderful paper. So questions? Please, Hannah.
Yeah, so I found this so interesting. And I just wanted to ask you to talk a little bit more about something you gestured toward at the end, which is the contrast or tension between this narrative understanding of felony and this kind of mental state understanding of felony, right? Because when I'm kind of thinking about, you know, the modern criminal law context, mens rea is like obviously the kind of structuring, one of the big structuring frameworks, and treated as sort of, you know, part of what justifies criminal law as an enterprise in the first place is this, you know, people are not punished for unintentional actions usually. And it seems to me that framework, obviously, insofar as felony is acting as a status in the way that you're talking about, sits very uneasily with it, right? Because the kind of mens rea concept is that there are, you know, that we're talking about kind of discrete intentions that, you know, are associated with particular acts as opposed to kind of this character identity. But thinking about it in terms of kind of the literary, the formal literary parallels of each, or the literary scaffolding of each. I'm very curious about sort of, you know, whether you see moments where kind of an impulse toward the sort of internalizing kind of emphasis on motive or a purpose or whatever sort of ever comes into tension with, or how that interacts with this kind of narrative understanding of felony, either in literature or in kind of actual criminal proceedings.
So I think, and I'm building here, and I think I said in the abstract, I'm building on Elizabeth Kamali's work on the beginnings of felony, and she makes the argument that juries did consider mens rea when they were prosecuting felony, that it was important to them, and that if it did not exist, they generally did not convict. And so and I agree, it's an active category. It's not put in quite that way, but there's a phrase that she draws out that like a felony done feloniously is that's the true felony, is a felony done feloniously. So it has something to do with the matter, and in particular with the mindset. I think that is true when it comes to how juries make their decisions. I think as a category, and how it's sort of, and we're all kind of, I think, talking about how the law functions in a broader sense as well. It retains this strong association with villainy, I think, to the extent that, so felony convictions now in the US are upwards of 90%, but at this point it's somewhere between 12 and 18%. So most people who are brought up on felony charges are not convicted. And I think part of that is in seeing felons as villains. And if you are being tried by a local jury, people who have known you or known your people all your life, they're less likely to, I think, class you as a villain than they are just, they might sort of agree that technically you did commit this felony, technically you did will this felony, and your reason consented to it. There's sort of all of this language, but you're not like a felon. And so I think a lot of the sort of jury discretion that goes on has to do actually with this narrative understanding that someone could be factually guilty of this, and yet you would hesitate to convict them because they don't fit this narrative understanding of the villain.
So that's a really wonderful question that Hannah raised, and it prompts me to ask what I think is a related question. So I had never really thought about the mens rea distinctions in the modern criminal code, the modern penal code, in terms of degrees of narrativity, but it strikes me that that's at least a plausible argument. So if you say that somebody did something purposely, as opposed to knowingly, as opposed to recklessly, as opposed to negligently, although the match is hardly perfect because one could imagine excellent counterexamples to all, there's at least a general sense in which the greater degree of intention also involves a greater degree of foresight, things going on before.
A temporal.
Yeah, exactly. So it strikes me that in a way what you've pointed at and your argument about its continuing force, the MPC might be, or the mens rea distinctions that we now believe in might offer yet further evidence for what you say.
That's really interesting. I think that's really helpful because the betrayal part seemed to me really interesting because it continues in sort of the prosecutions of felony, the reference to betrayal. And in order for there to be a betrayal, there has to be some kind of temporal, there has to be some sort of passage of time, because there has to have been trust at some point and now there is not. I suppose it could be a smaller amount of time, but it's usually longer. And so there has to be this sense of narrative. And I think what it actually transforms into is a betrayal of community trust, right? There's a sense that you were part of the community and now you have betrayed it, which again draws on this narrative framing that you were at one point a character in our story, and now you have been revealed to be a villain. And I think back to Hannah's question, another thing I was thinking about when you were talking, the centrality of the mens rea distinctions and sort of investigations into mens rea for our current criminal law. There's also the issue of felony murder, in which mens rea is not relevant. And it's one of the few places that it's not, where we're really willing to get rid of that. We're willing to get rid of both actus reus and mens rea, and, you know, get rid of the whole thing. And I think, and this is something I'd be interested in your thoughts on, but to me, my first thought about that is that we have in the felony murder, the sort of crime of felony murder reveals that we think about felony as committing a felony as having revealed your essential character. You are a felon, such that that kind of characteristic can be applied to anything that you do or anything that has happened in this commission of the crime. It's this sort of, you know, it's not an act, it's not a thought, it's who you are. And so that can then be applied much more broadly than we generally ever would. I don't know if there's anything similar, but that's kind of my instinct about it.
Yeah, so there's a lot in what you say. I would just add that Giora Binder, who couldn't join us today, has written probably the authoritative account of the history of felony murder. And one way in which perhaps you could reconcile your account would be to say that in order to get a conviction for felony murder, you nevertheless need arguably an unusually complex narrative that traces the death that occurred to the felony that resulted in the death in some way. So that not only is the narrative element present, although maybe in different ways than we'd normally expect, but at least some questions come into play about, you know, how the one occurred within the context of the other.
Yeah, I would just throw in, that's one of the things I was thinking, is that felony murder is like usually it has more of a robust narrative element than a lot of other kind of things, because it requires being in the commission of some other kind of planned felony. But I was just also going to say, like, this is one of the cases where vicarious liability sort of like connects to the idea of like status as something immutable, right? That like, in part because of your relationship with other people who are felons, you are brought to felon ambit. So, you know, I think, I don't know, it was definitely bringing things up for me in connection with some of the conspiracy stuff I was writing about. But yeah, it's particularly given what you were saying about this notion that when you are deemed a felon, the community is sort of ejecting you from its narrative in some way, or at least ejecting you from itself. I think it's interesting also to conceptualize it as being revealed to be part of a different kind of community or social network organization that is, you know, sinister in some way.
Yeah, and I think this is the approval network again is kind of coming in here, because one of the few ways you could sort of wiggle out of this, at least delay your punishment as a felon, was to turn approver and to report on your fellow felons. And it was kind of assumed that you would have that information, right? Because you are in cahoots with these people, no matter the nature of the crime. You could still, you know, find a way to turn approver.
Yes, please.
Yeah, so just that whole business of, you know, they're judging who you are rather than what you did. That's certainly the stuff that whole higher justice feeds on. That's very much the spirit of you know, post 1864. This is the climate of the Russian courtroom. It's very literature centric, very literature oriented, and they want to create these thick kind of psychological profiles of people on trial, so that they later say things like, okay, yes, she shot at the governor of St. Petersburg, but look at her life and look what motivated her. Appeal to, you know, look to your conscience. deliver, this higher justice sort of verdict, and then, she gets acquitted. So that's a historical trial I'm talking about. So that's sort of a scary thought. To me, this sounds super illiberal and very, very scary, this whole stuff about, judging who you are. But I have a very primitive question, and you'll see that I'm not a lawyer. So I just don't understand this basic point. They bring someone on felony charges. I think you even use this expression, right? So they grab someone, they bring him to court charged with felony.
Yes.
But then you're saying that felony is something that is defined by legal consequences. So how does it precede those consequences?
This is sort of the problem of the category. So in the medieval period, a felony was anything punishable by death and forfeiture of property. Now it is anything punishable by more than 1 year in prison in American law. And so we have things that we traditionally punish in that manner. But there is no attempt to rationalize or to sort of enumerate the inherent qualities that all of these things share. What does mail fraud share with aggravated assault? What are the sort of essential qualities that it shares? We've never tried to enumerate that. It's only ever defined by how we traditionally punish it. And so it's a matter of sort of common law tradition that, this crime usually gets you more than 1 year in prison, usually gets you death, and that's how it becomes a felony. But at no point is there a kind of justification of why something is a felony and not a misdemeanor. And so one of the cases I'm going to look at in the paper is the difference between robbery and theft. Robbery is a felony, theft is not. And so what makes them different? And then theft is in its punishment subject to degrees. So if you steal a very small amount, then you could get a lesser punishment than if you stole a lot. For felony, even if their justice is railing about this, even if you hurt no one and manage to take nothing at all, you are still guilty of a felony. So it's this kind of like blanket, anything that we kind of decide counts as robbery is a felony. But that's the problem, right? The tautology is the problem, that you are bringing someone up on felony charges without actually defining what a felony is.
No, and
that's kind of the problem.
Part, but you're talking about the present, and I'm asking about the historical trials you're looking at. So they grab the guy in the 13th century, right? They grab him on some charges that have some sort of significance, legal significance in the minds of those who grab him. And that significance, you say, can only be defined by the consequences that guy gets at that time in the 13th century. So that's what I'm not getting somehow. I understand about the present. I don't understand about the origin. When you're at the beginning of this narrative, right? Felony equals villainy and all of that. When they bring him to court, they have to have some conception of what they're bringing him for.
So the very technical,
before the consequences come about.
So the very technical answer is that it depends on jurisdiction. So the Crown adjudicates felonies. And so it depends on who you're bringing it to. And there's also an inherited sense of which crimes are serious in a sort of general sense. And, we can more or less enumerate them, though the edges shift. So, there's murder, there's rape, there's robbery, and there's arson, and there's treason. There's some slippage on the edges of that, but those are kind of the main felonies, but conspiracy also becomes a felony because then it's punished as a felony. So once conspiracy begins to be punished as a felony, then it's a felony. Before there was still the crime of conspiracy, but it wasn't punished as a felony, so it wasn't a felony. Does that make sense?
I think so. I mean, I'm still tripping on something here logically, I think, because you grab the villain, you bring
You grab the
him to court, right? He's a villain. He's sort of maybe not confirmed villain, but he's a villain. That's why he's there. Right. So it really, there's a conception of this before the consequence. Right. Imagine, I don't know, it's a sort of a thought experiment. This is the first trial ever of a villain, first villain in the whole universe. Right. You brought him on some charge, and this charge is whatever you name it, felony, you brought him there. It may not be a confirmed charge, like a confirmed crime yet, because it predates the jury, whatever work they do. But it was a concept before there was a consequence. That's all I'm saying.
So that's kind of my argument, is that felony does not have a legal definition. It's never had a legal definition, but it does have a definition, and we draw it from literature.
Yep.
All right. Well, thanks for a wonderful paper to round off, a wonderful forum. Thanks to all of you for participating, and I'll look forward to seeing it put on YouTube. Thanks very much.
Right. Thank you.
Thank you so much. It was really wonderful to hear your papers.